Straight ahead on Law and Crime Daily.
The judge's sentence incapacitates Keith Raniere for the rest of his life.
We dig further into the case of an alleged sex cult leader. Some of his followers still support him.
Plus, grand jurors speak out against the Attorney General, who said the cops who shot and killed Breonna Taylor could not be charged with crimes.
And a pro baseball player released early from a mental facility tries to escape blame after killing 3 people with a bat. Law and Crime Daily covers court cases from coast to coast.
And welcome everybody to Law and Crime Daily. I'm Aaron Keller along with Buckmire and Terri Austin. Let's begin with fallout from the 120-year sentence handed down against the leader of a so-called sex cult. Terri, bring us up to speed on that case.
Aaron, a federal jury convicted Keith Raniere of multiple counts including human trafficking, sex trafficking, racketeering, and the sexual exploitation of a child. The acting U.S. attorney said after court that the 120-year sentence incapacitates Keith Raniere, the ringleader of the group NXIVM.
This case involving NXIVM and Keith Raniere has really been about many tragedies and a few triumphs, and what happened in the courtroom today really felt like a triumph. It struck me in listening to the victims that Raniere really, twisted people's trust in their need to find some meaning and hope in their lives in just the most insidious and devious ways. When justice catches up with you, as it did today, it is severe.
Mark, Elliot, and Suneel Chakravorty are NXIVM members joining us live on Law and Crime Daily. Mark, glad you're with us. Have to ask this question, though. One of Raniere's accusers told the court that she was 15 and that Raniere was 45 when they started having sex, and she said he took pictures. She called it sexual and psychological abuse. Is she telling the truth or is she lying?
First, thank you for having us. It's nice to be here with you guys. Just to be clear, any of the statements that I make or any of the statements on behalf of Make Justice Blind, we do not condone abuse in any way. The things that we've been talking about are specifically to try to expose the prosecutorial misconduct around this case. And we believe, yes, I do believe that Keith Raniere is innocent. But what I believe is that when people see the level of misconduct and crimes that the prosecution and the government did to convict him, in time then will people then see the innocence that I also see. I can't speak about whether or not something did or did not happen. What I saw yesterday and why I made a public statement, which was so difficult, is that there was a woman who was allowed to have a victim statement that was not under oath or cross-examined. And her statements basically were allowed and played a role in condemning a man to a life sentence. While, our group, Make Justice Blind, has presented to the court undeniable evidence that's been corroborated by world-renowned forensic analysts that the hard drive that contained the alleged contraband was tampered with. And the court and just in general, the media has given no attention to that. That dichotomy, I think, is a problem in our country and for the justice system.
So you've got issues with procedure and you've got issues with evidence, and you accuse the prosecutor of committing crimes. That's a pretty harsh statement. Suneel, I want to switch over to you, though. Raniere said he was deeply sorry and that he caused his own situation. "This is all my doing," he said in a direct quote. What did he mean by that?
I was there. I think that, he feels responsible for the situation and for everyone who's been affected because he was the leader of a community. But as far as and feeling sorrow for the pain and the anger and the feelings of all those involved, but that can be separate from someone's innocence. So I think it was a good way to take responsibility for the situation while maintaining vigorously, as he has, his innocence of the charges.
So did Raniere do anything wrong, Suneel, in your opinion? Did he do anything that he shouldn't have done?
I think that is a broader question that requires more nuance. I think as far as what our focus is looking at, Keith Raniere was on trial. A jury of his peers found him guilty. He's facing a life sentence. What we're focusing on now and who we want on trial is the prosecution and what they did in this case in exposing that point by point.
So what specifically did the prosecution do wrong?
So I'm glad you asked. About a month ago, we as a group of citizens served the prosecution with a document, essentially an affidavit, containing 8 points of alleged misconduct, from lying to the court on small and big matters, to lying to the public, to threatening potential witnesses, tampering with evidence, and several other suborning witness perjury. And we have evidence on MakeJusticeBlind.com of those things, some of which had come before in motions to the court, and some of which are new evidence that's coming out. So if people want to take a look at the details, they should feel free to do so.
And certainly the documents out there. So, Mark, we've seen pictures of branding of women. That was the evidence the prosecution presented. What's the explanation for that? How do you take evidence like what you see on your screen right now?
So with respect to the women's group and the branding, obviously, I'm a guy, first off, so I wasn't a part of the group. And I think that the women's group just actually came out. Some of the women who are a part of the creation of DOS and members just came out with a thing called the Dossier Project, which I think is an incredible project where they're on their own terms and with their own voice talking about the women's group. So that's where I would direct people, where they can learn from the people that were actually in it, what this group was about. There's a funny thing on YouTube where if you type in change the soundtrack of a scene, it changes the scene completely. And for the past 3 years, people have only heard one soundtrack, which I would call a horror soundtrack, about NXIVM and about this women's group. And a lot of that is because of what the prosecution did to make it very difficult for there to be any other narrative. Mark Agnifilo, he even last week submitted a motion from Nikki Klein and Michelle Hatchett in which the prosecution threatened them as witnesses, if they so that they wouldn't testify. Even myself, while the jury was deliberating in this trial, I'm an inspirational speaker, and I was putting out a presentation about my story of how NXIVM helped me beat Tourette syndrome. And Moira Kimpenza called my lawyer, and my lawyer shared with me that she said that if I go through with this public presentation, that she would throw me in jail.
Wow.
So just to be really clear,
these are tough accusations. We're running out of time here, gentlemen. So certainly appreciate the conversation. It's a case that we're going to continue to follow here at Law and Crime Daily. Thank you very much for your insight into the group.
Thank you.
Thank you.
A former city council member and attorney accused of sex trafficking in Ohio is free after posting bail. In other stories we're watching, Michael Moran faces 18 felonies, including selling some of his female clients for sex. A judge set his bail at $300,000. In court, Moran said he didn't have the cash and was working to raise the money. Ohio's Attorney General told Law and Crime Daily he'd be watching to see who posted the bail in case it was a conspirator hoping to buy Moran's silence. Court records say an indigent defense fund posted the money. A man is charged in Las Vegas with killing a 2-month-old baby by throwing her off a second-floor balcony. Authorities say the newborn died from blunt force trauma. 32-year-old Clarence Martin Jr., seen here, is charged with murder and arson. Police say he also set fire to the place and killed a dog in that process. Martin took off in a Mercedes. Police arrested him at the airport. A New Hampshire woman is accused of pretending to be a prosecutor and filing fake court papers to get an earlier case against her thrown out of court. According to an indictment, 33-year-old Lisa Landon filed a motion to drop her cases using the name of an assistant county prosecutor. She's charged with 1 count of false personation and 6 counts of falsifying physical evidence. Her underlying case involves stalking and methamphetamine possession. Got to ask about this. Brian, Terry, impersonating a county prosecutor by putting that person's name on your court papers and saying, oh, this case should be thrown out. Brian?
I am looking back at my own case and being, my clients are obviously not working hard enough to get rid of their own cases. I know it's a crime. I shouldn't be laughing, but it's a low-level crime, and this is the most hilarious thing I have ever seen a defendant ever do. Please, viewers, don't do this on your own, but wow, I don't even know how this could have happened, Aaron. This is bewildering in so many levels.
Terry, I mean, should they throw the book at her at this point? I mean, what's your take on this?
Actually, that is my take on it. I mean, it begs the question, what security measures were in place and what should we be doing to thwart these types of fraudulent activities? It's frightening that she was allowed to impersonate a prosecutor, actually go in and file papers. And if it hadn't been for this forensic examiner who was, scheduled to perform an evaluation on Landon, and he saw that the charges against her had been dropped, we would not have known about this. So fortunately, he was there. He contacted the county. He said, what happened to the case? It looks like it was dropped, and that's how we found out about it. But my whole point is we need more security.
We do. That might be one solution here. And still ahead on Law and Crime Daily, the trial of a baseball player accused of using his bat to commit triple murder. But first, two of the grand jurors who examined the police shooting of Breonna Taylor have harsh words for the Attorney General of Kentucky as the only officer indicted heads back to court. We're right back with that report. Welcome back, everybody. Lawyers for the Louisville Courier-Journal are fighting to get access to discovery materials in the police shooting of Breonna Taylor. Officer Brett Hankinson has pleaded not guilty to 3 counts of wanton endangerment for firing shots into Taylor's neighbor's apartment. Hankinson's lawyer and the Kentucky Attorney General's office have asked the court to seal the materials to prevent information from tainting any potential jury pool. The judge in the case appeared skeptical of the argument.
When you say, Ms. Whaley, that the cows would let the cows out of the barn, I mean, in this case, as we're all aware, there's been a lot of publicity, some of which has been generated by the Attorney General's office itself. So I find it hard to accept your arguments in toto because I don't see you coming to this with clean hands.
Potential jurors would not be able to set aside this amount of detail in the public record.
2 grand jurors who examined the Breonna Taylor case are speaking out. We're going to jump in now with Law and Crime's Brian Buckmire, bringing us up to speed with their harsh criticism for the process and the Attorney General. Brian.
In an interview with CBS, The Morning's Gayle King, 2 grand jurors said that the police covered their tracks. They said they listened to 20 hours of testimony and that it was, quote, betrayal for the prosecutors and to only present 1 charge against Hankinson. They said almost the entire room was shocked when prosecutors say there were no other charges that would stick. One said there was an uproar in the grand jury room over the way the case played out. They were also very critical of the Attorney General's press conference announcing the sole charge.
The first time I heard the word 6 possible murder charges was in that news conference.
It wasn't presented to you in the grand jury deliberations?
No.
I really felt that this was all camera. This was up to him. We didn't get a choice in that at all. So I was livid. By the time I heard what he was saying, everything that came out of his mouth, I was saying liar, because we didn't agree to anything. We never met Cameron.
Pretty harsh words there, Terry, from those jurors. A couple of other points from that interview. The attorney for the grand jurors told CBS that the process was backwards, that prosecutors wanted the grand jurors to follow them rather than the other way around, following the law.
This was a very unusual case, Aaron. The fact that these grand jurors are coming out and speaking and saying to the public that this isn't what happened, and the fact that they hired an attorney to help them reveal what happened is also quite unusual.
And Brian, the grand jurors also said they found Taylor's boyfriend, Kenneth Walker, credible and totally believable. They said the police were not believable in those proceedings. Too many inconsistencies. That also is very, very damaging.
It's extremely damaging only for the Attorney General, Daniel Cameron, because what we're seeing is how a grand jury should not work. This is not the way grand juries work in any state, in any county, in any place in the United States of America. And what you're seeing is this gentleman bastardized this process in a way to ensure that a result that he wanted came out rather than actual justice.
Harsh words from the Law and Crime Daily commentators as well here for the Attorney General of Kentucky. And when we come back here on Law and Crime Daily, the trial of a former professional baseball player accused of using a bat to kill 3 people, 2 of them relatives. Will his mental health defense work? A former pro baseball player is on trial for allegedly using a baseball bat to beat 3 people to death inside a California home. Brandon Willie Martin faces 3 counts of first-degree murder for the deaths of his father, Michael Martin, his uncle, Ricky Anderson, and a repairman, Barry Swanson, who just happened to be there on a job. Prosecutors say in 2015, Martin blew through his $800,000 in earnings, had no jobs, no friends, and no prospects. They accuse him of committing the murders out of anger. His defense says he suffers from mental illness. Police officers responded to the victim's house just days before the attack for a call about the defendant being aggressive towards his family.
Information I received was that he had been involved in a physical altercation with his mother 2 days prior to a contact with him. Couldn't get a statement from her because she had left the residence. And speaking with his brother that day, he told me that Brandon had picked up a pair of scissors.
Wait, not going into the facts.
Oh, sorry.
Just why was it that you didn't arrest him?
There was nobody there that wanted prosecution for any criminal activity. Based on the information given so far, the only other option I saw was detaining him for placing him on a 5150 hold for a psych evaluation.
Were they upset that that Mr. Martin was placed under a 5150 hold?
Yes.
And did you give them the option as to whether he could be arrested or placed in a 5150 hold?
Yes, I told them that I didn't feel comfortable leaving him there, so the only other option would be criminal prosecution, but based on the behavior, he's being placed on the hold.
Okay.
In California, the so-called 5150 hold allows for a person to be held for a mental health evaluation for up to 72 hours. Martin's defense said he was released after only 48 hours and then went on to commit the murders.
And just so it's clear, it wasn't up to them what was going to happen to him. It was up to you. Is that right?
As far as the hold, yes.
In other words, you're taking in, you want input from these folks, but ultimately the decision is yours. Is that right?
Correct.
Okay. Was Mr. Martin at all resistant when you placed him in handcuffs and placed him in the back seat of the car?
No.
And you were the one that transported him to the ETS facility, correct?
Yes.
During that drive, did you have any interaction with him?
I don't recall any interaction with him.
Was he at all resistant or combative in any way on the drive over to the facility?
No.
And when we come back, officers describe a gruesome crime scene, and a recorded phone call made by one of the victims captures the attack. That's right after this. Let's head back to the trial of Brandon Willie Martin, who's using a mental health defense to try to beat a charge which could send him to death row. The victim's family hired ADT to install a home alarm system when they learned he was going to be released from a mental health facility. The technician, Barry Swanson, was at the home working on setting up the alarm system on September 17, 2015. He was on the phone in a recorded call with his employer when he was attacked.
All panic and arrests. Barry, can you hear me? ADT Field Support, this is Barry. May I help you? Are you still on the line?
Authorities responded to the home to find a gruesome crime scene, 3 bodies and a baseball bat covered in blood with the defendant's name etched into it.
Somebody either had blood on them and they rubbed up against the wall, or something. It could have maybe been a rug or a piece of clothing or whatever, but something rubbed and the blood was transferred. Or if the blood was already on the wall, it got moved around. So it's not caused, this particular pattern, by blood flying anywhere. It's caused by something rubbing against the wall.
Could that be if somebody was in a pool of their own blood and trying to move and get up or something, and they had blood on their hands and they were wiping it on the wall?
Could be any sort of movement or contact between the wall and an object where there was blood involved.
Terry and Brian back one more time here on Law and Crime Daily. So Terry, hard to listen to that phone call with the employer's representative basically just saying, are you there? Do you need help? And it's hard to tell what's going on, but it was an attack.
it's a horrible case, and it's a tragic case, and it's an ironic case. The fact that the ADT installer himself was there putting in a system to protect the family against the individual who ended up killing them. And, you know, frankly, I think that this is a case of where the system failed someone who had a mental illness, but I don't know if there's anything you could have done to avoid this type of incident.
Brian, is the defense playing the long game of trying to prevent the death penalty here and almost rolling over on the core murder case, or do you think they've got a shot by basically blaming the mental health system for releasing him early?
So I think they're actually picking their battles. In California, it's a two-part trial. The first, deciding whether or not they're guilty or innocent. And the second part, I think, is the major battle they need to win, because they're going to say that he's guilty. Absolutely. The facts are pretty bad on this case, but because of his mental instability or mental defect, they're going to try to save his life in that sentencing phase.
So, Terry, what do you think? Same question to you. Do you think they're playing the long game here, or do you think they've got a shot by pointing the finger back at the mental health facility?
Well, I think that the mental health facility could have done more, and I think it's a good argument. But, you know, even if they had kept him for the 72 versus the 48, I don't think that would have made much of a difference. I think what would have made a difference had they given Brandon the attention that he needed, the medication that he needed, the counseling that he needed. Other than that, letting him out 48, 72 hours wouldn't have made a difference.
Yeah, and it might blow back at the jury trying to basically blame someone else for an act that they're basically admitting that the defendant committed. Brian and Terry, appreciate the discussion. We're out of time here on Law and Crime Daily. We'll see you next time for our discussions about justice in America.
Hi, I'm Dan Abrams. In the exploding legal and true crime genre, Law and Crime is the only network that has it all.
Good evening and welcome.
This is a complicated case.
Don't really jump to conclusions.
We break down the case of a serial killer.
Another day of drama between both sides.
From multiple live trials daily to original and compelling programming, the Law and Crime Network is everywhere, and we invite you inside the jury box. This is Law and Crime.